Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1079 et al. Jones Lang LaSalle Americas, Inc. Petitioner versus National Labor Relations Board. Mr. Laminack for the petitioner, Mr. Said for the respondent.
Morning, counsel.
Morning.
Mr. Laminack, please proceed when you're ready.
Thank you. May it please the court. Once again, the board is in court defending the actions of one of its agents in the conduct of an election. And once again, the board's defense is grounded in conflated and confusing standards that are devoid of any reasoned explanation and that fail to adequately protect employee free choice. It seems straightforward for a board agent conducting an election. Don't leave the ballot box unattended and unsealed. Don't leave blank ballots unprotected. And don't leave the voting area during a polling session to find potential eligible voters. It seems especially straightforward where, as here, the polling periods were only 30 minutes long. So why did this misconduct occur? We don't know. And that's not a question for this court. The question for this court is whether the regional director, whose decision the board adopted, properly applied the correct legal standard or standards in evaluating JLL's objections, and whether the regional director provided a reasoned explanation for the standards she purportedly applied. The regional director expressly recognized in her decision that there are multiple standards when board agent conduct is at issue. She recognized one standard where the conduct tends to destroy confidence in the election or could reasonably be interpreted as impugning the election standards. And the other, she recognized, considers whether the conduct raises a reasonable doubt as to the fairness and validity of the election. She then acknowledges there are no absolute guidelines before going on to appear to apply the reasonable doubt standard with respect to part of JLL's objections, and then also recognizing that tends to destroy confidence standard, at least in a footnote she acknowledges may apply with respect to the objection concerning the board agent leaving the voting area.
What's the difference between the two standards?
The primary difference, Your Honor, between the two standards is the degree of prejudice or the degree of harm to which a party who's objecting must show. According to the regional director, in some of the board's cases under the reasonable doubt standard, there must be more than speculation. In other words, just because misconduct occurred, that's not sufficient to overturn the results of an election.
It would be okay under the tends to destroy confidence standard?
Yes, Your Honor. Going all the way back to Austell and some of the early cases decided by the board that specifically address misconduct by a board agent in connection with a ballot box or blank ballots, the board has consistently held in those cases that appearance is everything. Okay, it's destroying the confidence in the standards that the board purports to uphold in conducting elections.
So it's harder for you to win under the reasonable doubt standard.
Our position is it is a tougher standard if the regional director correctly applied the standards to show if you're going to speculate as to what happened. But even under a reasonable doubt standard, the actions of the board agent in wholly leaving the ballot box and blank ballots and then going and looking for eligible voters, that conduct alone is enough to demonstrate a reasonable doubt as to the fairness and validity of the election.
There's parts of your opening brief where it seems like you're arguing for the reasonable doubt standard.
Right.
So why why did you do that if it's a
Sure,
standard for you?
Sure. So the reasonable doubt standard, we mentioned in our opening brief, and we cited it as part of the standard of review, but throughout the opening brief and throughout early portions of this case, including in the request for review, which is the initial challenge to the regional director's decision, and then in an expedited request for consideration to the board, and in our opening brief, there is a focus on the regional director applying the wrong standard. And until this court issued GHG management after we filed our opening brief, this court's focus and interest in requiring the board to articulate and explain which standard applies to which objection and to provide that reasoned explanation.
Do you think GHG broke new ground, or do you think it was just applying law as it already existed?
I think GHG broke new ground in the sense that it is the first time in a appellate decision that I've reviewed with respect to board agent misconduct that it calls the board to task for failing to provide that reasoned explanation. So while that standard has always been there, provide a reasoned explanation.
Would you concede that the argument you're making about the NLRB insufficiently explaining why it applied different tests at different times in your case, would you concede that that argument is forfeited by not being in your opening brief if we conclude that GHG did not break new ground?
I do not concede that at all, Your Honor. Throughout our brief, again, we recognized and we argued both standards. We argued whatever you want to call the standard. And again, as this court has recognized, the board has not been clear at all on this issue. But however you want to describe the standard, it doesn't require us to have a proof that something untoward happened. Okay, the offer of proof demonstrated that the board agent left the blank ballot boxes, left the ballot box and left the blank ballots and then walked around. That alone is the evidence of the unfairness of the election. And for the board to suggest that that was a waiver issue is inconsequential here.
Counsel, can I give you a different perspective and read this? So I read it in your order of proof for the board. It was unclear what standard you meant to have the board apply. You offered a couple. The regional director considered the couple that you recommended. The regional director applied both standards to both alleged unfair labor practices and found that you failed no matter what. That's the way I read what the regional director did. And then in your initial brief to us, you said material affected the results of the election is the test. No matter what you think this alleged intervening case says, you said that was the test, and the board certainly applied that. I don't know, in all honesty, I have no idea what you're talking about in your argument today. All the tests that you're talking about, the regional director considered. Whether you think it was a clean opinion, it's clean enough for me to understand what the regional director did. And you were not clear to the regional director in saying which standard should apply. And the regional director applied both standards to both alleged unfair labor practices and found that you had not made out any case.
Respectfully, Your Honor, I don't believe that the regional director explained or articulated both standards and found that we did not satisfy both standards. So
if I can write it that way, you would concede you lose, right?
I'm sorry?
If I can write it that way, you will concede you lose, right? That the regional director gave consideration to both the standards that you raised. And you were completely unclear as to which one applied in your order of proof. That's what's a little strange in this case.
Yeah.
You're self-righteously accusing the board of being confusing. Your initial order of proof was confusing as to what you meant to apply. But the thing that seemed important to me was the regional director applied them both. Whether or not you thought it was as well written as you would have liked, it was well written enough to make it clear that both of your alleged standards had been applied and that you would lose on both. And then your initial brief to us, without regard to this alleged change in the law, which I don't really understand, you said material affected the results of the election. The board certainly applied that as standard. The regional director and the board applied that standard, which you stated to us in your opening brief was the standard that should govern.
Your Honor, we stated that it was the standard, a standard, reasonable doubt,
No,
but we also.
You said in your opening brief, I went back and looked this morning, I was trying to be sure, on page 11, materially affected the results of the election. That's the standard you said to this court should apply.
Right.
Then you thought you had something in August because a case came out from this court and you thought you could raise an argument, oh, they didn't fully explain what they intended to do. You said the standard that should be applied was this, the board did apply it, and they said you lose on it.
Your Honor, in GHG, the court illustrated why the board must articulate the appropriate standard of consideration of board agent
There are an
misconduct.
awful lot of cases, counsel, in this area and in other agency cases where if an agency applies all of the alleged standards to all of the alleged illegal conduct and says you fail under all of them, that's enough. And that's what happened here.
Well, the regional director's decision acknowledged multiple tests and then cited cases in her decision as to prior board agent misconduct as it relates to ballot boxes. But again, in GHG, this court recognized that that's not enough. And for us to.
No, counsel, you're missing my point. If what the agency does is to say, okay, here are all the tests. Now here's your claim. We're going to apply all of those tests to all of these facts. And every time we apply it to all of your alleged ULPs, you lose. That's perfectly okay.
Well,
You're in real trouble if the agency says every test that you lay out here, we're going to apply to your alleged mistake, and we're going to find you have no merits.
But I don't agree that she did that. If she did that, the conduct itself, leaving the ballot box, leaving the blank ballots, walking around, that conduct itself raises a reasonable doubt. It also fits squarely with some of the prior board cases, which hold that the mere appearance alone casts doubt on the integrity of the election.
Do you agree that the regional director, at least however you read the decision, made a determination that the alleged problems here did not materially affect the results of the election?
I believe that she conflated and confused the standards, and
You think she made that determination?
I think she.
Their reading of the decision cause a person to say she was determining, however badly you think she wrote it, she was determining that this conduct did not materially affect the results of the election. Wasn't that her determination?
That was certainly what her determination was.
And that's your standard. And that's the standard you stated in the opening brief, and that's why you should lose. That's the standard you said to this court should be applied. I agree. And you acknowledge that the regional director applied that standard.
But we didn't acknowledge that we lose under that standard
No,
either.
I understand you're saying notwithstanding that, we should still win. That's a different point. But you certainly acknowledge that standard and you agree the regional director applied it.
She applied the standard, but again, in light of GHG, she has to do more than that. So for example, you mentioned, well, no matter how poorly her decision was written or reasoned, well, that is precisely what GHG management says you can't do, board. You can't just cite a bunch of standards. You can't cite prior case law and say, oh, this is different from that case. And so we're going to apply this and here's my decision. You can't do that. That's what this court says she cannot do. And throughout our offer of proof, the request for review, and even in the opening brief, we relied on and argued that there must be an element of appearance at issue. And it's not enough to just say, nothing happened, so what's the big deal? That's not appropriate. GHG.
I think she did more than that.
Colleagues have additional questions for you?
No.
Okay, we'll give you a little time for rebuttal.
Thank you.
Hear from board counsel now.
Thank you, Your Honor.
Mr. Side.
Good morning, Your Honor. May it please the court, David Side, for the Labor Board. happy to discuss the particular merits with respect to each part of the company's objection, but if I could just go directly to the allegation that the board applied different standards to different parts of the objection. As Judge Edward indicates, the company not only admitted in its opening brief that reasonable doubt is a proper standard and therefore has waived that claim and it's by trying to raise it for the first time in the reply brief. In fact, its opening brief doesn't even mention the language of the supposed second standard or even cite to a case that contains such language. And then just also this court simply has no jurisdiction to consider it because it was obligated to have raised it to the board, which again, like its opening brief, it never did before the board. But just very briefly, even if this was somehow before the court, which it isn't, as Judge Edward indicates, the regional director's decision discussed the reasonable doubt standard, said there's some different language that is used at times, but then very specifically at page 40, says at bottom, the test is reasonable doubt. However, the judge then goes on, as I think Judge Edwards indicated at appendix page 41, the employer argues that the board agents above conduct impugn the integrity of the election and proceeds to find that it rejects that argument. And then at page 43, note 7, the judge proceeded in addressing the second part of the objection to cite to two cases, the Polymers case, which of course sets forth the reasonable doubt standard, as well as the Athro case, which does use tendency to destroy language. So the regional director clearly, to the extent that anything other than reasonable doubt applied, covered by including cites to both cases. And I would also just finally point out, unlike the GHG case, the company here has not shown that to the extent different language may be used at times, that the overall burden placed upon it to show a material effect on the election and to show more than, and to show more specific evidence that that's not the ultimate responsibility, regardless of what language is used, nor has it made any argument that the result would be different. And again, as indicated, the regional director clearly, to the extent there is even arguably a different standard, applied and looked at both parts of the language, not just reasonable doubt, but also a tendency to destroy.
Yeah, I thought of GHD, which I know a little bit about since I've been the author. The predicate for the analysis was the board's implicit understanding in that case that the difference between the two standards actually could be outcome determinative.
That is correct, Your Honor. So that was a situation, again, as I'm sure you're well aware, where there is alleged voter disenfranchisement. And the board applied a different standard, whether the voter disenfranchisement was based on something the board agent did or versus something that someone else did, such as the Postal Service. Here, we are ultimately dealing only with conduct by the board agent. And again, the company, besides not even raising the issue about different standards to this court timely or properly, hasn't even argued that ultimately there would be any difference in whatever language is used or that the outcome would be different. Unless this court has any.
One quick
Sure.
question. It's not appropriate for the NLRB agent to go get out the vote, right? Like what happened here?
Well, Your Honor, there's the board's case handling manual does not, which is a guideline to start with, does not contain any language that prohibits a board agent from checking to see if somebody is outside the door waiting to vote or seeking to vote. It would be inappropriate if, arguably, if the board agent compelled somebody to vote or went searching throughout the facility seeking to try to find voters, but that there's no evidence that that's what occurred here.
No, go. No,
I thought that the agent here at least was alleged to have encouraged them to vote, which is a step beyond, what you're saying is allowed.
Correct. So the allegation here with respect to that objection is that part of the objection is that the board agent compelled somebody to vote. And all the proper shows is that the board agent indicated that he was going to see if anyone was around to vote, left very briefly.
There's a gap between seeing if there's anyone left to vote, which, okay, maybe that's allowable, and compelling someone to vote, which is not allowable. Somewhere in between there is not compelling someone to vote, but encouraging them to vote.
Right.
And it seems like that's also improper. You
Correct,
agree?
but here, I cannot emphasize enough, it was incumbent upon the employer in its offer of proof to present some sort of evidence that an employee was forced or compelled to vote. Here, not only did it not fail to proffer such evidence.
You keep saying
But the-
forced and compelled, but I'm just trying to, maybe it may well not matter for this case, but I'm just trying to get some clarity.
Sure.
It is improper for an NLRB agent to encourage someone to vote, correct?
It would generally be improper based on, again, on the particular facts of the case. And here, the evidence does indicate, at least for one employee, that that employee was actually simply waiting outside, thinking that he had to wait outside to be called to come in to vote. So it was incumbent upon the company to have shown more, which it simply did not do here.
And I just want to follow up on this just out of curiosity, is encouraging somebody to vote, if there's undisputed evidence that what a board agent does is go out and tell people, look, you should know that the polls close in 15 minutes. You know, if you want to vote, you should vote. Is that improper?
Your Honor, I'm simply not aware of the board ever addressing that type of fact situation. And as this court knows, the board does address cases on a fact by case basis based on the facts. So it simply would not be appropriate for me to speculate if that's all an agent did was to let somebody know that the polls were going to be closing, as opposed to going out and actually telling somebody, hey, come with me, you have to vote. Or certain
Right, the
foreign
compelling one
fighter
is
voters.
easy. I guess on the, something short of compelling, which is just notification that if you need to vote, you should vote, or even encouraging, or even saying, you know, you should vote. I'm not telling you which way to vote. I don't care which way you vote. You should just vote. Is that acknowledged?
Yeah, I'm not aware, certainly as, and not trying to avoid the question, certainly compelling is on one side of the equation. I'm not aware, honestly, and during elections, if it's ever announced that the polls will be closing in 10 minutes or in 15 minutes to make sure that people who haven't voted yet have the opportunity to do so, particularly when polls may be open for 3, 4, 5, 6 hours. I honestly do not know if announcements are ever made to that effect.
And if they would be improper if they were.
And if correct, Your Honor.
But I mean, the main point here is this is contextual. The board regional director is looking at the facts that have been offered to determine whether or not it's likely to have adversely affected the rights of the employees. And I think the finding here, as I understand it, is this nonsense. One person was just standing there waiting to vote, certainly was not encouraged to do anything. And all the board person responsibly doing was to let person know it's available if you want. But in any event, it's a determination that is made based on the context presented. And I think the finding here was there was nothing to show that this failed any one of the tests that are applicable, right?
That's correct.
Okay, thank you.
Your Honor, the board would simply ask that the court enforce its order. Thank you, Your Honor.
Thank you. Alamanak will give you 2 minutes for a rebuttal.
Thank you. Briefly, Your Honors. In its request for review, the employer specifically and expressly argued that the regional director found no evidence of harm, but this is not the appropriate standard. Long-standing board precedent holds that an election must be set aside when there's even an appearance of an irregularity. In the request for expedited consideration, JLL argued that the regional director focused on the heightened standard for setting aside elections. Throughout the opening brief, despite recognizing the reasonable doubt standard as a standard for review of these board decisions, JLL relied heavily on Austell and Athbro and other cases in which harm need not be shown. But regardless, Your Honors, even under a reasonable doubt standard, JLL was deprived of a hearing. And it wasn't because there wasn't a proffer of evidence of misconduct that led to harm. There was an absolute proffer of evidence of misconduct in the form of the board agent leaving the blank ballots, leaving the ballot box unattended, and walking around. that is enough evidence, at least in an offer of proof, to warrant a hearing to validate whether that was appropriate under a long line of board cases. Judge Walker.
You don't allege that the last two people to vote, you don't allege that they would have voted against the union had the election been conducted in a pristine manner, correct?
Well, that's a reasonable speculation. There was no offer of proof of that. That's a reasonable consequence of allowing a board agent to, or not, keeping a board agent within the polling area and not having others around to observe it.
But I don't hear in your answer any evidence that those two voters would have voted against the union.
There is no evidence that was proffered.
They might have not
Correct.
voted at all.
Correct.
That maybe is a fair inference. But if they had not voted at all, the election result would have been the same, correct?
Presuming that nothing untoward happened in the polling area when the board agent was out and the ballot box was unsealed and blank ballots were left there. Again, it's
You had an
speculation.
observer there,
I'm sorry.
where there were observers from both sides there.
There were observers from both sides there, one for the employer who was not an actual voting employee, but that's not sufficient to satisfy the standard of whether it's conduct that impugns the election standards. And certainly enough evidence based on the board's prior precedents to warrant a hearing to develop this and then allow the regional director and ultimately the board to make a reasoned explanation for why it is deciding what it is deciding. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Case number 23-5288. Tobias Jones, appellant versus United States Secret Service of the U.S. Department of Homeland Security et al. Mr. Yablon for the appellant, Ms. Lilly for the appellees.
Good morning, counsel. Mr. Yablon, please proceed when you're ready.
Thank you. Good morning, and may it please the court. The district court's decision that there could be no remedy against Secret Service officers for First and Fourth Amendment violations should be reversed, both as to monetary and non-monetary relief. First, on Bivens, the court concluded that because the Secret Service has some national security responsibilities, any claim against Secret Service officers arises in a new context. That result is untenable, as the government does not dispute it would slam the door shut on claims against officers of practically every federal law enforcement agency, because nearly all such agencies, like the Secret Service, have a mix of national security and traditional law enforcement functions. That includes officers employed by agencies like the Park Police, against whom this court has held there is no question a Bivens claim may lie. As a fallback, the government contends that the officers here fall outside Bivens because they were themselves exercising the service's protective functions. But that position is unsupported by the complaint and totally counterfactual. The service's protective mandate is narrowly defined by statute and includes the protection of specific high-ranking government officials. The defendants here are officers who are checking IDs at the office building where they worked, not guarding the president. There are simply no national security concerns implicated here. Second, as to standing for non-monetary relief, the district court ignored the extensive precedent holding that a person challenging restrictions on expressive activity need allege only a credible threat of enforcement. All that is required to infer such a credible threat here is to take the defendant officers at their word that filming the Secret Service building from a public sidewalk was prohibited and would result in search and seizure.
I don't remember you discussing the First Amendment theory, at least not very extensively in your brief. It seems like maybe we should find that you haven't preserved that argument.
In terms of the merits or in terms of the Bivens claim?
Yes, in terms of the Bivens, that if you alleged at some point before the appeal that there was a First Amendment Bivens action that should be brought here.
That's correct. So we
I think I've
pleaded,
abandoned that.
we pleaded both. We did preserve that issue and we discussed in our opening brief, but we acknowledge that that is foreclosed by this court's precedent. We're preserving it only for the possibility of further review.
Okay, so
But we acknowledge that
for our
Buchanan.
purposes, you hang your hat on the Fourth Amendment. Bivens.
Correct.
And then are you aware of any cases that extend Bivens to a stop and frisk?
To a stop and frisk specifically, I think outside this circuit, the Seventh Circuit's decision in Snowden v. Henning is fairly analogous to that. That was I'm sorry. Well, that was the use of excessive force in a hotel lobby. There was also Hicks v. Ferreira in the Fourth Circuit. That was a police car stop. I think the closest in this circuit would be Lash v. Lemke, and that was an excessive force claim.
You just named 2 excessive force claims and 1 vehicle stop. So I think the answer is no. You don't know of any cases that have extended Bivens to a stop and frisk.
Sure, and so I would just emphasize that here we had both an unlawful search claim and an excessive force claim. And, those two were, maybe in some sense connected. But yes, but I think in every relevant sense, this case is just like Bivens. It is a Fourth Amendment search and seizure violation by line level law enforcement officers doing ordinary law enforcement activity. And so I think that the theories that the government has advanced to distinguish this case and say that this case is a new context, for one, don't include that sort of stop and frisk distinction, but also are just completely overbroad and would have really profound implications in terms of wiping out this court's prior decisions in this area.
On the question of whether the dismissal and whether you should be granted, whether you should have a chance to amend, did you seek leave to amend in the district court?
We did not. So the district court didn't specify in its order that we would be permitted leave to amend. And so under Rule 41B, that operated as a final decision on the merits of the issues decided. I think that, the government hasn't made a waiver argument here. They acknowledge in their brief that if there's some basis for that, if there are amendments that could save the complaint, assuming that there are problems with it, that we should be allowed to make those. And so I think even if there was potentially a waiver issue, there's also a waiver of waiver issue. The government is not.
Going back to the excessive force point, I get that you argue there should have been no stop and should have been no frisk. Beyond that, what force was excessive?
So I think the application of any force to Mr. Jones' camera was totally excessive because there was no basis at all for that. Shoving Mr. Jones' camera, I think, any quantum of force, if there's no reason for it whatsoever.
Remind me, if you would, what the complaint alleges with regard to.
Yeah, so there were kind of 2 components to the excessive force claim. There's shoving the camera, and then there's later.
That even means shoving the camera.
Pushing Mr. Jones' camera away.
Did they break it?
I don't believe so. I'm not aware of that. But so subsequent to that, the officer also.
Do you know of any cases that discuss excessive force toward a camera or even excessive force toward an inanimate object?
Not offhand, although I think excessive force applied to an individual's, personal possessions on their person falls squarely within that. But regardless, the officer after that tackled Mr. Jones, forced him to the ground, handcuffed him.
Is that in the complaint or is it just in your brief?
It is in the complaint. So the complaint says that he was forced to the ground and roughly handcuffed, and that afterwards he was on the ground, shaking with fear, This was just totally disproportionate to the, zero indicia that
Is there
there
a way
was
to
anything
force
wrong.
someone to the ground without tackling them, I would think?
That may well be possible. I think,
And that's what the complaint says, force, right? It doesn't say tackle.
it does not use the word tackle. That's correct. If that is a salient difference, we'd be happy to, amend to clarify. I don't think that has any bearing on the remedial issues that are on appeal now.
Can I ask a question? So, the recent Supreme Court decisions, I mean, you'd be hard pressed to find a language in Supreme Court decisions that more tells lower courts be wary in the Bivens context. And some of this language is pretty pointed. And in that light, at one level of generality, you could always say it's just like Bivens because it also involves a law enforcement officer carrying out law enforcement functions and vindicating law enforcement functions in a context in which a Fourth Amendment violation arises. And at that level of generality, I think there's a lot of things that would be encompassed by Bivens. So the question is, at what level of generality did you describe it? And one, there is a distinction in some sense in that even if the particular protective function that was being carried out here, in your view, wouldn't qualify as national security because you're construing national security as something pretty narrowly focused on exactly what the Secret Service's charter is in that area. The officers who were carrying out the functions on the day of the incident, they were still involved in the protective function of protecting a government facility.
So I don't think the protection in that general kind of, protect and serve sense qualifies as a new context. I think
Not protect and serve, because I take that point because all officers are protecting and serving. That may be a slogan that applies to all law enforcement in America, but I'm talking about protecting a government facility. So it seems to me that you could argue that that's a different context than law enforcement functions out in the field and in some ways, what the Supreme Court has asked lower courts to do is to, based on separation of powers, think about the way Congress might approach this. And I guess the question is, couldn't Congress approach it differently based on whether an officer is protecting a government facility? And that's what people at the security booth do. They're protecting a government facility, as opposed to officers who are out in the field enforcing the criminal law.
Sure. So I think I have three responses to this. The first is that the government hasn't made this argument. The government has focused on the Secret Service's protective functions, arguing that they were acting pursuant to a unique statutory mandate, invoking that basis for distinction in Ziegler v. Abbasi. And so that's what the government has argued here. Bivens is not jurisdictional. Ordinary rules of party presentation applied. And so I think at the very least, this court should say, the government's arguments for saying this is a new context are wrong. The district court's reasoning was wrong. And it should at least be vacated on that basis. But I also, I see I've hit time. But
I want to hear your other two. Please.
So beyond that, I would say that this is the exact, checking IDs at a driveway to a parking lot is the exact same sort of everyday normal law enforcement stuff done by officers of practically every agency around the country, state or federal. And simply because it could be characterized as protecting a building, I don't think can make the difference. And I don't think that that sort of day-to-day law, the fact that it's important is not a basis for saying it's a new Bivens context. All law enforcement activity is important.
I agree with that.
Yeah.
I don't think there's a distinction in terms of level of importance necessarily, because you never know what the threat is going to be in any particular instance. It could always be something, whether you're out in the field or you're protecting a building. It just strikes me that it seems like arguably a different context when of course, it's garden variety law enforcement in that it happens a lot. But the question is it a context that could be seen as distinct from the context in which Bivens arose, even though they both involve Fourth Amendment?
I think drawing a distinction at that granular level really would not be much different than saying, if you're not named Bivens, your claim can't proceed. There are always ways you could characterize a particular action by line level law enforcement as
no rational Congress would authorize a private action only for people named Bivens. But then the question would be, could a rational Congress authorize a private cause of action that doesn't encompass protecting government facilities because the balance of consideration seems different in that context.
And again, I think when you're dealing with activity that looks no different from, next door, you could have had, some private building where there's private security guarding the parking lot. And next door to that, you could have some municipal building where the DC police is, checking IDs at the parking lot. I do not think that checking IDs at, this driveway implicates these sort of national security concerns. And again, I'd emphasize that the government's, basis for identifying a new context here is the Secret Service's unique protective mandate. And this activity clearly doesn't fall
And what was
within
your
that.
third? What, did you already do your third one or did you?
Yeah, I believe so.
You did. And what was it? So just so I make sure I remember the distinction between the second and third one.
I think I may have blended the second and third, but I've completed my answer. Yeah.
Okay.
And I see that I am out of time. I just want to make sure that if there are questions on the standing arguments, I have an opportunity to address those.
Okay. Thank you. We'll give you some time for rebuttal. Lily.
Morning. May it please the court, Janie Lilly for the defendants. As this court has, the panel has identified, inventing a novel damages remedy for Secret Service officers engaged in their protective mission is contrary to the instructions of the Supreme Court and this court, which has asked courts to look at precisely the balance of policy interests that Congress would have to consider were it to extend a damages remedy into a novel context. And the Supreme Court has instructed that the new context inquiry is a broad one and that it's easily satisfied, and that has done so.
Can I ask you this? So the Secret Service engages in garden variety law enforcement, right? I mean, they obviously have the protective function with protectees, but they can also go out and investigate crimes.
Your Honor, the plaintiff has pointed to the investigative missions related to cybercrime and counterfeiting, and it's pretty clear on the allegations of this complaint that those weren't the missions involved.
No, I'm not talking about this case. I'm just saying in the abstract that can happen.
That there are, yes, that there are certain specific investigative.
So if a Secret Service member, a Secret Service agent is out carrying out that function and then does what happened to Bivens, would you acknowledge that a Bivens cause of action could lie there, even though the particular officer who carried it out was a Secret Service officer?
I think that would present a very different case. The Supreme.
No, they would present a different case than this one. I get
Right.
that. But I mean, so put aside this case. I'm just asking for the breadth of the government's theory.
Yeah, I don't know after Egbert whether the Secret Service's mission in investigating cyber crimes or whatever was issue there might differ. Again, the context is
Even
important.
if the conduct was exactly the same as the conduct that Bivens faced.
Your Honor, the Supreme Court has said that that's not sufficient, that those factual similarities are not sufficient. But again, I think we're pretty
I don't
far
know that we
afield.
know that. I don't know that the Supreme Court's ever said that because the officer who carries out the exact same conduct as was carried out against Mr. Bivens is employed by a different agency, that would itself mean it's a different context for Bivens purposes.
I'm not sure in those words, but the Supreme Court's new context inquiry has said it's broad, it's easily satisfied, and the
Right,
non-exhaustive
so that's
list
why
of
I'm
factors
asking.
are.
I'm just asking for the government's view on, I'd take your point that the
Right.
context inquiry is heavily tilted in favor of the government in the way that it's articulated by the Supreme Court. It
Right.
used a lot of language with italics that emphasize that, but I'm just wondering about the government's theory. Would the government take the position that if the conduct that was visited upon a citizen was the same as the conduct that it was visited upon Bivens and happened even in the same place, but it was carried out in the course of an investigation of something that's within the Secret Service's charter to investigate and a Secret Service officer did it, that would not be within the fold of Bivens?
Your Honor, I don't know whether an investigation of counterfeiting or cybercrime would ever involve that type of similar conduct at issue at Bivens and whether
I think it could, and I'm just hypothesizing that it does.
Yeah, I mean, I think that a fair reading of Egbert would suggest that the identity of the defendants and the statutory mandate under which they were operating would be a fair basis for distinguishing that from Bivens. But the court, this is very far afield from.
How would you define the context of Bivens then? Because we have to, in order to apply Bivens, we have to know whether something is a different context. And
Your Honor,
it's always been based on context that we'd be saying it's different from.
I'm not sure that the court needs to define the core context of Bivens, because two officers standing out in front of Secret Service property who are, responding to a member of the public with an unusual direction of interest inside the building, and who repeatedly refuses to comply with their directions, are very far afield from any of the conduct at Bivens. So I'm not sure the court needs to
I'm not sure
address.
that we need to for the purpose of this case, but I'm just wondering, from the government's perspective, how would you define the context of Bivens? Because it seems like the way the rational court would conduct the inquiry is to say, at least for thought experiment purposes, is that we have to decide whether something's a new context. A new context from what? A new context from Bivens. Okay, then that requires us to ask, well, what's the context of Bivens, so that we can analyze whether this thing that we're facing is a new context.
I think that's right. And the Supreme Court and this court have described the holding of Bivens in ways that makes it very easy to distinguish this case from that, as an excessive force claim by officers who invaded or who conducted a warrantless and unlawful search in furtherance of routine narcotics investigations. So I think that's how the Supreme Court and this court
The
have
routine
described
narcotics
this.
investigation kicks in, I guess, then if it were a different law enforcement agency that were also conducting narcotics investigations, and it wasn't, I mean, obviously the agency that was involved in Bivens doesn't exist, then that would be governed by Bivens.
It might be, Your Honor. Again, the new context inquiry is very fact specific. And so I would.
Even that one might be.
Well, I'd be loath to sort of commit the government on the stand here to some position in a future case where the Supreme Court and this court have instructed is a very fact-intensive inquiry. So especially in this case where I don't think the court needs to define the outer contours of Bivens to hold that these Secret Service officers who were protecting this building engaged in their protective functions is an entirely new context.
And what if we weren't necessarily persuaded that these officers in this context were involved in the standard national security function of the Secret Service, but they were involved in protecting a government facility?
Your Honor, I think that the court could also find a new context on that basis, although the district court found the facts or the factual allegations sufficient to conclude that this was pursuant to their protective functions. And I think the questions that the court has posed and the suggested intrusive discovery that plaintiff has suggested in order to parse whether the president or the vice president was in the building at the time are precisely the type of separation of powers concerns that the Supreme Court has said gives rise to a new context for the purposes of the Bivens inquiry.
There are certainly times when the government does insist on inquiring whether, for example, a criminal defendant knows whether the vice president is in the building or not, right? We just decided a case, this court just had a case about that where the government said it's quite appropriate to. There was a dissent, but the government won on its argument that it's appropriate to inquire into whether a criminal defendant knew he was trespassing into an area where the vice president was present.
That may be, Your Honor. I think
The
here.
government doesn't have a blanket rule against kind of discovery and inquiry into whether the vice president is in a particular place. In fact, some of their criminal prosecutions depend on it.
That may be, Your Honor. I think the new context inquiry under the Supreme Court's instructions in Egbert and Abbasi would preclude precisely that type of parsing and that type of intrusive discovery. That's a further reason that this presents an entirely new context.
The narcotics agents in Bivens were working for an agency that has a national security mission, right?
Your Honor, yes, it's certainly under plaintiff's theory that.
And that alone seems like it means the district court's reasoning was wrong here, because the district court's reasoning seems to be, well, the Secret Service has a national security mission, so it's different than Bivens. But the narcotics agency in Bivens also had a national security mission. So that can't be the distinction between this and Bivens, this Yeah, that can't be the distinction between this case and Bivens.
Your Honor, I think that's not necessarily a accurate characterization of the district court's holding. One identified that it was a different mission than in Bivens, and the unique statutory mandate of the Secret Service that implicates
What is
national
the
security.
different,
And
in terms of the agency's mission, not the point of the particular investigation or stop at issue in the case, but the agency's general mission, what's the difference between the narcotics agency, I guess today it's the DEA, I think at the time of Bivens, maybe it wasn't called the DEA, and the Secret Service? It seems like they both have a national security mission.
Your Honor, I think the district court was very clear that the special mission of the Secret Service involved in protecting high-level government officials, sites of national importance, foreign missions, was vastly different than the statutory mandate under which the officers in Bivens were operating when they were conducting a narcotics investigation. I think that is very, very clear.
Because the Secret Service's protective purposes serve a national security purpose, right?
Yes, Your Honor, that the protective functions that have been entrusted to the Secret Service and which Congress has determined, the scope of which Congress has determined for the Secret Service are vastly different than those at issue in Bivens. And then the district court.
The DEA does not have a national security mission?
Your Honor, the Supreme Court has not instructed the courts to look at the sort of invocation purely of national security, but it looks to whether the specific statutory mandate under which the officers were operating is different. And that's the focus of the new context inquiry and the district court's analysis.
The DEA doesn't have a statutory mandate that involves national security?
It involves a different statutory mandate. And to Judge Srinivasan's point earlier, thus the Supreme Court has instructed crafting a novel damages remedy in the context of Secret Service's own mission would involve a different policy balance that is better entrusted to Congress than the courts.
I think you can agree. I think you can win the case without relying on the district court's reasoning here. And maybe you tell me if you agree with this. One of the ways you win the case is Egbert was really quite similar to Bivens. So in order to have a Bivens action, you need a case that's even closer to Bivens than Egbert, which is definitely not this case.
I'd be happy to win the case on that ground, Your Honor.
Okay.
No further questions? I ask that the court affirm the judgment of the district court.
Yablon, we'll give you 2 minutes for a rebuttal.
Thank you. A few brief points. The DEA has had statutory national security functions since at least 1978, probably some earlier, but that, certainly by then. I think the agents here clearly were not involved in exercising their protective functions. Those are defined by statute under 18 USC 3056 and 3056A. There are specific individuals, specific sites. It's not some capacious mandate to protect whatever. These are it's really a narrow function. And I think it's really not right that the distinction in cases like Hernandez and Egbert were small. Those were cases in Ziegler as well. You had a cross-border shooting, you had enforcement, directly related to interdiction at the border, and you had detention of individuals who were persons of interest in 9/11. So those were all cases with really huge national security implications that I think far exceed what was going on here. And to the extent that the government has preserved, I don't think they make this in their brief, the argument that simply standing guard checking IDs at any federal building is a new context. I do think that there is at least a fact dispute about whether that was really what was going on here, at least with respect to the second officer who wasn't at that guard post. This really looks like two officers coming outside the building because they were unhappy about being filmed. And that's a totally different context. Given that the government hasn't even made that narrower argument, I think the court should limit itself to saying that the district court got this wrong. And finally, just to say a little bit on the standing issue, I just want to make two brief points. One, this court has said expressly in Payne, cited in our brief, that in terms of the standard for standing under SBA list, even a challenge to they're standing even to challenge an informal policy. So it doesn't matter. I don't think the government has denied that there's a more formal policy, but even without that, there would be no issue. And Mr. Jones alleged that he regularly engages in this type of journalistic activity, and on remand, we'd be prepared to say that he would go back and film this particular building on a date certain if this, threat of being subject to this excessive force and unlawful search again were removed by a favorable decision. We'd ask the court to reverse.
Thank you, counsel. Thank you to both counsel. We'll take the case into submission.
Case number 23-5310, Battle Creek Health System et al. Versus Xavier Becerra, Secretary of the United States Department of Health and Human Services, appellant. Mr. Kennedy for the appellant, Mr. Houck for the appellees.
Good morning, counsel. Mr. Kennedy, please proceed when you're ready.
Kevin Kennedy for the government. The Provider Reimbursement Review Board has jurisdiction over challenges to determinations of the amount of the payment that hospitals will receive under Medicare. Under the Medicare Act and its implementing regulations, CMS makes such challengeable payment determinations at 2 points. First, where payment amounts can be determined prospectively, it does so in its annual rulemaking. Second, where payment amounts can only be determined retrospectively because they involve cost-year data, it does so in notices of program reimbursement. That scheme makes sense. It consolidates review so that once hospitals know precisely how much they'll be paid, they have one opportunity to challenge any feature of their prospectively set payment amounts and one opportunity to challenge any feature of their retroactively determined payment amounts. Plaintiffs' desired approach, in which they could challenge one component of a payment amount, and the district court's holding below would upend that scheme. It would create uncertainty over which determinations sufficiently relate to payment to warrant review and bog down the PRRB in piecemeal litigation over interim determinations that may or may not bear on the ultimate payment amount. This court should reverse the decision below. I welcome the court's questions.
Well, I have a question that's wasn't really brief, but it's about redressability in these circumstances. So what would happen if we ruled in favor of the challengers, given that, as I understand it, the payments for that year have already been made based on whatever ratio ultimately was deemed to be the appropriate one for FY 2007. And so what's at stake here in concrete terms with respect to that year? And what could be done with respect to that year?
So if the PRRB had jurisdiction over the challenge, then I believe they could obtain a recalculation of the amounts in their notices of program reimbursement, according to, if in fact the Part C days.
Part C people so the idea would be it was wrong to include the Part C
days issue in the Medicare fraction. And there would be some question about how then the amounts of the dish payment should be calculated if that was incorrect. But they might obtain a different payment amount if so.
Okay, so the government doesn't have any issue with the fact that I know you have a lot of issues with whether the PRB had jurisdiction, but if the PRB did have jurisdiction, then the government has no problem with this case can go forward.
We haven't raised a standing argument here, Your Honor. And I think, we think that the PRB's dismissal.
Or mootness, I guess it would be.
Or a mootness argument. I do think it's, it is odd that they have challenge fractions that were not ultimately used to make their determination as the amount of payment, which we raise in our finality argument, but we haven't raised a standing or mootness argument here, Your Honor.
The CMS never reconsidered or revised its choice to count Part C patients toward the Part A populations. Is that correct?
Between the time that these fractions came out, I think that's right. After the fractions came out and between the time that notice of program reimbursement was ultimately issued. But again, the issue of the Part C days itself does not determine an amount of the payment. Yes.
And then, but one of the reasons that you say it's not final, and the statute requires a final determination, Secretary is the amount of payment under, but you say, well, it's not final because it could have been revised. And of course, there were things that were revised after 2009, of course, but as you just said, the decision to count Part C patients toward the Part A population, that was not revised. So under your theory that it's not final if it merely could have been revised, does that mean that no publication of Medicare fractions could ever be final?
No, Your Honor. Our argument on finality is that the disproportionate share adjustment, you look to whether it represents the culmination of the agency's process on something. And the culmination, according to the regulations, occurs at the final determination of payment, which is in the notice of
But even
program
that could be revised, right?
It could have been revised.
So it can't be the case that the test is it's only final if it cannot be revised.
I agree with that, Your Honor, and I think that's black letter law. The question is not whether some final action could have been revised, but whether the action in question was final.
And that action in question did reduce hospitals' dish payments, correct?
No, Your Honor. The Part C days, I mean, so for the hospitals here, they don't know at the time that they receive their Medicare fractions whether they will or will not receive a disproportionate share adjustment. The CMS issues Medicare fractions for every hospital, but it doesn't go on to issue dish payments for every hospital because only those hospitals that, based on the later computations that the Secretary still needed to compute, qualify.
So did it either reduce, it seems like it had to either reduce the dish payments or for some hospitals completely eliminated the dish payments, right?
I think there are some hospitals who might have fallen below the line no matter what. So there's no direct link. But again, that's not the question under the statute.
There's no hospital, well, there's no hospital that got an increase in dish payments as a result of the choice to include Part C's in the Part A population, correct?
I think it's conceivable, but I'm not sure, Your Honor. But I think that, again, the statutory question is whether the challenged determination settled the amount of payment, meaning in this court's terms, the per patient amount. And the Part C days, the resolution of the Part C days issue certainly did not. And
were there any remaining variables for the government to, in its expertise and discretion, make a decision about?
Absolutely. So in addition to the Medicare fraction, the disproportionate share adjustment requires the agency to compute the Medicaid fraction.
Right, but I thought all the numbers that go into the Medicaid fraction, the hospitals already have.
So they have the cost report data, but it's not just math that goes between cost report data and the ultimate Medicaid fraction. There are interpretive choices that the agency needs to make. They need to decide, for example, how to determine who is eligible under a Medicaid plan and how to count patients participating in demonstration projects. So both of those interpretive choices are sort of a major variable between the cost report data and the ultimate disproportionate share adjustment that is the per patient amount that they can challenge.
And was that not the case in Washington Hospital?
So no, Your Honor, as this court recognized, the secretary had acted in a final manner as to both. There were only two variables and it acted in a final manner as to both of them. So they knew precisely how much they would be paid.
Washington Hospital?
In Washington Hospital.
Washington Hospital said there were things that could be varied later. This was just an aspect of the final payment. That's why I don't understand how this case is not controlled by. Why? I'm just reading it right now. They were very clear that this was just an aspect of, and I don't see how you're conflating a little I and a double little I.
So
A double I is not the same language as a single I. And you just jumped right over and I was stunned by your opening. We have precedent at least this judge appears to be directly on point, and Judge Wald addressed all of your points, and the fact that it is merely an aspect of the final payment does not mean that it's not a final determination, she said. And that's exactly what went on here, and she acknowledged that it could change later, that the final determination could change later, even though this aspect could be challenged now. And you're just ignoring all of that.
Respectfully, Your Honor, I disagree. If I can address Washington Hospital
No, you
first.
can't disagree because your opening was 1 minute. And you never mentioned Washington Hospital. You never attempted to deal with the precedent in the circuit. It's directly on point.
Well, if you'd allow me, I'd like to address it
I
now.
would like for you to.
Okay, so in Washington Hospital, that language, some aspect of the payment calculation is describing the challenges that the providers there brought, not the determination that triggered the jurisdiction in that case. And if you look at the determination that triggered the jurisdiction in that case, the court is very clear that it settled the final variable factor and thus produced a per patient amount. And it was that per patient, the availability of that precise per patient amount that hospitals could challenge under Romanet 2. Now, I agree that Romanet 2 and Romanet 1 are different provisions that have different scope. Where, for example, in the federal base rates of payment through its annual rulemaking, the agency determines prospectively the amount that hospitals will be paid under their base rate. It settles all the variable factors in that calculation. Providers can and do challenge under Romanet 2. It's simply the case where it hasn't reached a determination as to all of those variable factors that they cannot.
Because this one's retrospective.
This one is retrospective.
So you don't know until later.
That is right. You don't know until later. Just taking a step back, hospitals regularly challenge their disproportionate share adjustments through their notices of program reimbursement or where there's an untimely reimbursement. This court has heard cases about disproportionate share adjustment, the agency's position on Part C days, because hospitals regularly raise those challenges against the notice of program reimbursement or in the case of an untimely reimbursement.
So I guess the question is, do they have to, they might well do that regularly. And the question is, do they have to wait until then? And on that, can I just ask you, just as a practical matter in the way the world really works, you get the Medicare fraction, and then it's true that you don't know to a moral certainty what the final amount is necessarily because there's also other inputs. There's the Medicaid fraction, but there's also a bunch of information that the hospital actually has. And so I assume that what's happening when the hospital gets the data that was gotten here before the claim was filed was that they're then projecting what their dish payment is going to be. And because they have a lot of information that would give them that. And I guess my practical question is it true that, there are instances and a fair number of instances, or at least a non-trivial number of instances in which what a hospital would forecast at that time actually turns out not to be the amount that they get?
Absolutely. I think projection is the key word here. I mean, in addition to, and I will address Your Honor's question, it's not only sort of the delta between the amount in practice, it's also the fact that the statute sort of describes the component calculations and assigns those to the secretary. So I think it's very odd that providers could get ahead of the secretary under the language of the statute. But addressing the amounts.
Before you go on to it, because I want you to bracket about the amounts too, but was that different in Washington Hospital?
That was different.
On the way the statute talks
If you
about it?
read this court's decision, it says the determination as the per patient amount had two component variables. And it looked to see whether the agency had acted in a final manner with respect to both component variables. And so there, once the agency acted with respect to the second variable, it triggered the jurisdiction to review. So the agency had, by its own regulations, acted in a final manner on both of the things that mattered. Here, there are at least, there are multiple variables, but at least the Medicare and the Medicaid fraction. And if you look at the statutory language, it says an additional payment amount for the disproportionate share adjustment. I'm paraphrasing there, but then it says, you need to calculate at least the Medicare fraction, or you need to calculate the Medicare fraction and the Medicaid fraction. So just according to the statute, there hasn't been a final action on this second component. And I think that it's not only a statutory point, it is also a point about, in practice, how different the hospital's estimation is going to be from the actual numbers that come out in the disproportionate share adjustment. So on that point, you can imagine a situation where the the agency's position on how to treat patients eligible for Medicaid or patients under a demonstration project. I believe Your Honor had a case about this recently. They didn't have a position on the books at the time the Medicare fraction comes out. And so they have rulemaking and they determine their position on how to do those things in between when the Medicare fraction comes out and when the Medicaid fraction comes out. So that's going to put a huge wedge between, a provider can't know exactly how those rules are going to come out. So there's a big interpretive question that could sort of come between when the providers think they can know how much they're going to get and when they actually know how much they're going to get. And then in every case, in addition to that sort of interpretive question, in every case, the Medicare contractors audit the numbers that the cost reports that the hospitals submit. So if you look at the cost report is what they use to estimate their DSH payments, but the Medicare contractors audit them, and they often remove Medicaid days from the count. And so we point to a couple places in the administrative record, I believe at 109 and 110 of the administrative record, where in this case, as to some of the hospitals, the contractors remove days, so that's putting another wedge between the amount that they're estimating and the actual amount.
So in terms of those two examples of wedges, what happens if that kind of wedge situation arises after what you even concede would be final? Where is the NPM? I'm forgetting the acronym, but
The Notice of Program Reimbursement, yeah.
NPR. Okay.
NPR.
So at that point, it's become final under your estimation too. And then you could still have the scenario in which, could you still have an audit and something could get reconfigured, or is it too late to do it that way?
So I'm not sure of the total extent of whether there could be an audit, but I think in that case, you would absolutely have, at the NPR definitely triggers jurisdiction to challenge before the PRRB. So whether or not there might be a reopening or some other audit, whether or not there could be some other change that happens to the disproportionate share adjustment, you absolutely can bring your challenge before the PRRB once you have a notice of program reimbursement. I should also say that sometimes it takes a long time to issue these notices of program reimbursement, and my friends on the other side are very concerned about the delay, but there's also a backstop. If the notice of program reimbursement does not come, if you've submitted your cost report and 12 months elapse, you can then bring a challenge before the PRRB. So I think that the concerns about sort of delay here are substantially overstated.
Do you think that there's a difference in the meaning of the text in the statute and the text I'm about to contrast with that? So the statute says final determination of the secretary as to the amount of the payment versus, imagine it said final determination of the secretary of the amount of the payment. Do you think that as to versus of should matter?
I think both of those would require a determination that sets the actual amount of the payment.
So I get why that would be the case for of, but something as to sounds like kind of related to or about, and think of a hypothetical off the top of my head, but a missed free throw can relate to the final score of the game, but it's not the final score of the game.
So I think if the statute said related to the amount of the payment, that would be a very different case, and that's sort of the interpretation that the other side is positing. But I do think as to draws quite a clear connection between the determination and the amount of the payment. But even if Your Honor disagrees about as to, which I think is sort of necessary, you have to interpret it in context because it's this sort of connector word. If you look elsewhere, just at the language immediately preceding this in A, it says for those hospitals who receive payments in the amount calculated under sections B and D, and then it refers to such payments, they can challenge such payments. And so I take it to be the whole scheme is referring to the actual determination of payment, an amount of payment. And just to make a sort of a more policy-oriented point here, if my friends on the other side were right that it meant something like related to, then they could challenge their Medicare fractions. They could separately challenge a rule about how the agency was going to consider eligible days under Medicaid. It could separately challenge a rule about demonstration projects, all before they have received any of those had gone into an actual payment amount. So it's hard for me to see how that would actually expedite review and ultimate determination of the payment amounts.
Or
That's
they
helpful.
Okay.
That I do find that helpful. I did think of a better hypothetical though. I think it's
Hit me. All right.
So imagine it's the first half of a basketball game and the referee makes a final determination about a foul. And that foul leads to 2 free throws that are made. It seems like it would be a final determination as to, what became the final score, but it's not the final score. And it seems like that's sort of what's going on here. The secretary has made a determination as to the amount of the payment because the secretary has made a final determination that is going to reduce at least some hospitals' dish payments, even though it's not an actual final payment.
I don't know that I think in the basketball example, which I appreciate, there would be you would say that would be a determination as to the final score. I think it's a determination that affects the final score, but a determination as to the final score would be, if they had to, figure out if a shot went in at the buzzer, and it did, it did in fact go in, and then they went to the score table and they said, okay, the final score is 103 to 100. That's the determination as to the final score. All the prior determinations, I think, might affect the final score, but they're not determinations as to the final score.
All right, I'll think about that.
To follow up my colleague's example, it's like instant replay. You're entitled to instant replay, even though it may not affect the final score, but it has an impact on the entire process. And you say, no, that call was wrong. I want you to stop now. And
So-
we want a determination now as to what the correct call should be.
As much as I enjoy the basketball analogy, I am going to steer us back to the statutory text and say, the question is whether it determined an amount of the payment. And because it did not, because many of the hospitals that receive the Medicare fractions will never go on to receive disproportionate share adjustments, and none of them know precisely how much they would be paid. It doesn't satisfy the statutory
What
text.
kind of, if it really meant related to, and it was the outer perimeter of related to, as in bearing on, as in could potentially affect, how many claims would the PRRB then get from hospitals? Because how many, I mean, you know this scheme better than I do. How many determinations are there that could affect the final payment amount?
I mean, I think there are myriad. I can't put a number on it, but I agree with Your Honor's point that this would bog down the PRRB in many, many determinations that, only might bear on determination. And I'd point the court to this court's decision in Monmouth, where it said, some procedural decision that might bear on the ultimate payment amount is not one that establishes or alters the actual payment
This seems
amount.
more like a substantive decision than a procedural decision, a substantive rule versus a procedural.
I agree, but I think it's just as far away from, it bears just as indirect a connection to the actual amount of payment, in that it does not set an amount of payment, and it doesn't sort of in every case affect the amount of payment. But again, to Judge Srinivasan's point, the scheme that plaintiffs propose in the district court's decision would countenance is one that would really bog down the PRRB in many determinations, that simply, it makes sense to consolidate review at one point. That's a familiar scheme from the law. I think you have one point to challenge the rates that the agency sets prospectively after the IPPS rule, and this court sees many of those cases, and you have one chance to challenge after the notice of program reimbursement, and this court sees many of those cases as well. And that scheme works, and it allows plaintiff hospitals to challenge all of the methodological choices that went into their payment amount determinations.
I'm not going to ask hypothetical. One of the amicus briefs has some dictionary definitions of as to, and those definitions include with respect to and concerning. Now, I think what you'll probably say is, context matters. Context always matters. And I agree. I thought one of the takeaways from Washington Hospital is that the context here is that Congress made a choice that things like this would get decided earlier rather than later, once Congress shifted from the kind of retrospective regime to a more prospective regime.
So I agree context matters, and that is my broad point. I think the context of this payment is that it is retroactive. You necessarily need the cost year data to figure out the per patient amount. And so in that context, it makes good sense that, you would challenge it at the end of the cost year when the total per patient amount has been determined. So Washington Hospital concerned a prospective payment, which is different than
A prospective payment.
a prospective payment. Yeah, sorry.
Are there ever any times when a determination does not resolve every remaining variable that would affect the payment, and yet the determination can be challenged under A1, A2?
So I don't think so, Your Honor. That's our test, that they have to, that those determinations that trigger the PRRB's jurisdiction under Romanet 2 are those that resolve the last remaining variable, such that all of them have been resolved and you know precisely the per patient amount.
What about and I don't recall the details of Shands Jacksonville off the top of my head, but does Shands Jacksonville pass that test?
So I believe that's a challenge to the annual rulemaking. And in that case, the federal base rates, there has been a determination as to the amount of the payment with respect to the federal base rates, which are, they include the wage index, they include the standardized amount, they include the labor-related share, but the annual rulemaking determines all of those variables. And so once the annual rulemaking comes out, there has been a final determination as the amount of payment because it determined all the variables in the formula, and hospitals know precisely how much they'd be paid per patient for any hypothetical patient.
One of the briefs says Shands Jacksonville presupposed that A1, A2 authorizes review of the individual components of the base per patient calculation. And that base calculation consists of at least 5 components. Do you agree with that description of Shands Jacksonville?
Yes. So that, though I think that description sort of conflates the determination that triggers PRRB review with the methodological choices that a provider can get review of upon challenging such a determination. So there was a final determination as the amount of payment. The IPPS rule, for the reasons that I've explained, it settled all of those 5 variables. And then once you have a final determination as the amount of payment, you can get review of the agency's choice of how to resolve any of those variables.
But your point is that you can only get that after all of the components have been decided.
That's precisely right, yeah. Thank you, Your Honor.
Thank you, counsel. I'll give you a little bit of time for rebuttal. Mr. Hauk.
Good morning, Your Honors. Drew Hauk for the Applee Hospitals. May it please the court. This case does not require this court to break new ground. Rather, the hospitals ask it to reaffirm nearly 40 years of settled law regarding the plain language of subsection A, Romanet 2. At stake is judicial review of agency actions that directly affect the rights of hospitals to review of fair payment for treating vulnerable patients. You should affirm for 3 reasons. First, the Secretary's publication of the Medicare fraction meets every test for finality. It marked the end of the agency's decision-making process and imposed direct consequences on the providers. Second, the text of A, Romanet 2 plainly permits this kind of pre-NPR appeal. It lets hospitals challenge determinations affecting dish payments or rates without waiting for an NPR. Requiring otherwise simply collapses A, Romanet 2 into the preceding section, erasing Congress's protections for providers. Such a reading undermines these safeguards and worsens the harms Congress sought to prevent. Finally, delaying review when the outcome is a fait accompli allows errors in critical payments to persist, compounding financial harm to hospitals potentially for years and jeopardizing access to essential programs. Nothing could be further from what Congress intended with the faster, predictable process that was baked into A, Romanet 2. Therefore, the hospitals ask this court to affirm the district court's decision, finding that the board has jurisdiction to hear this appeal. With that, I welcome the court's questions.
But why isn't a lot of what you say countered by the fact that this particular payment differs from a lot that otherwise occurs under the statute, because this particular one is retrospective? And so with respect to this particular one, you need more information before you actually know the amount.
Well, Your Honor, for 2 reasons, Your Honor. First, the idea that it's solely retrospective is factually inaccurate about how dish payments work. It is adjusted retrospectively. That is accurate. When the NPR is received by the hospital, there is an adjustment to the payments that have already been made. But it does, the dish adjustment sets a rate that is prospective.
What do you mean when you say the payments have already been made?
There are interim payments that are made. So hospitals receive over the course of a year prepayments on an estimate of what their dish payments will be throughout the year. Those are made based on an estimate by the agency of their former cost reports of previous years. So for example, that's exactly why the June 2009 decision is so important. You'll see in the record, there was a transmittal issued in 2010. The agency noted that the June 2009 data was going to be used by the agency to make payments to the hospitals prospectively. They were going to get these dish adjustments prospectively. Those will be trued up at the end of a cost year. So it is true that there's a retrospective adjustment, but that's to make accurate the payments that had been made in real time over the course of a year, Your Honor. So it is both prospective and retrospective. The second reason, and you'll find this rationale noted in Washington Hospital when this court was first addressing how do we understand prospective payments. They're not necessarily just prospectively paid. They're prospectively set. It's not accurate to think of them as prepayments entirely. And that's exactly how the DISH statute or how the DPP, the disproportionate patient percentage here works. It sets a percentage ahead of time, and the hospitals get advanced knowledge of what that percentage is going to be and how it's going to impact them. It impacts them, as the Supreme Court said, by putting the Medicare Part C days here in the denominator of the Medicare fraction, makes the fraction smaller and, quote, reduces hospitals' payments considerably. That's not really rejected by the government. That's the known outcome of putting the Medicare Part C days in the fraction. And by doing so, it certainly has a negative impact on the hospitals. And that's all the statute requires. It requires dissatisfaction by the providers, by a determination made by the secretary that impacts their payments in certain sections of the Medicare Act. And those certain sections include the DISH section. And that's exactly where you'll find this calculation that's made by the secretary that includes these payments.
So if the secretary, if there's a similar thing that happens here, but in the very item that's at issue, that's under review, the secretary says, by the way, don't bank on this because we're still looking into this and you shouldn't take this as the definitive word because we're, whatever they did the second time around with this payment, you think that that would still be final and it should give rise to the ability to go to the PRRB?
Yes, Your Honor. And that's because if we take the facts here, we should measure finality at the moment that the secretary first publishes this data to the website. It was the final determination of the agency about where to put these Part C days. Even when there was some indication given that they may not use this data to calculate reimbursements for these cost years, in this sense retrospectively, that they wouldn't readjust the DISH payments for 2007 and 2008 cost years. Subsequently, the agency said in 2010, actually, we will use that very data. That June 2009 data, we will use to give your interim payments for 2010. It's not as though this was some temporary or proposed information they were going to use. It was the very data they did use. And it's still this agency's policy. The Part C days still remain in the denominator of the Medicare fraction. Nothing has changed. And just as importantly here, there was some discussion of alternative methods for how hospitals might otherwise be able to appeal. These hospitals, during the course of their administrative appeal, they took what Congress gave them as the first chance. They had the first opportunity to appeal this, to quickly resolve this, and the agency during that course of that process, their intermediary indicated that there were no jurisdictional defects with the appeal. And when another determination came around that they could have appealed from, they did not appeal from that. That's true. But they didn't need to. They had no indication that what they had was a faulty appeal at all. And that door closed on them. And now they're left with this being...
The PRRB said it was not properly brought before the board, right?
7 years later, Your Honor. And there were no other alternative appeals for them to file at that point. I think it's also important, we've talked a little bit about hospitals that might receive NPRs that will have DISH adjustments because they're actually receiving these payments. My friends on the other side noted one key factor of the DISH structure here, the secretary's determination, it's also a threshold determination. Some hospitals won't receive a DISH payment. They won't receive interim payments. They won't receive a DISH payment on their NPR to be adjusted. that means they won't have anything to appeal via an NPR. They won't have an A Romanet 1 appeal. They won't have an appeal to be made for not having received an NPR that they could have appealed from for their dish adjustment. This is the prime avenue for them to appeal. So it's a very important method, which is exactly why Congress would have placed this appeal in this part of the statute, to make sure that these sorts of determinations, which have an impact on thousands of hospitals, could be handled quickly and efficiently.
No, you please.
I was gonna kind of shift a little bit.
Yeah, go
I feel like you've always let me go first today.
ahead.
I feel bad. Mr. Kennedy said he thought it might be conceivable, at least, that a dish payment could increase as a result of counting the Part C patients toward the Part A populations. Do you agree with that?
Yes and no, Your Honor. No, I don't think it's conceivable that counting the Part C patients in the Medicare fraction can increase a dish payment. I understood something slightly different to have happened, and I think it's very technical, so I apologize. Adding the Part C days into the Medicare fraction is going to always lower the dish ratio or the SSI ratio, the Medicare side of that fraction. But it's only 1/2 of the DPP, the larger.
Medicaid fraction.
Correct. The Medicare fraction, or the Medicaid fraction could conceivably go up. There could be days that are added into that or patient days that are added into that. And a provider could see that side of the fraction increase. And so in total, the payment that a provider could receive at the end of the day could be a larger payment. That's what I understood that discussion to mean. The provider's position, though, would still be that because the Medicare Part C days are included in the Medicare fraction, they would have always expected to still have been larger. That if you would have taken those Medicare Part C days out, it still would have been larger. So in layman's terms, if it were 10% plus 10% at the end of the day, so you had a 20% fraction, but if you took the Medicare Part C days out of the Medicare fraction, it would have been 11% plus 10%. You would have had a 20% DPP. That's the difference. The delta would be the 1% difference that the hospitals would view as their damages in this case for including the Medicare Part C days in the denominator. Does that make sense?
A little, maybe. I mean, I'm guessing that if at the end of the day, you ended up with more money, you would not, be here standing on principle and saying, oh, no, we deserve less money because the
Well,
fraction should be higher, one fraction should be lower.
Well, under that example, you'd end up with more money still if the Part C days were further out because both fractions would be going up, not one fraction going down and one fraction going up for the end ratio.
So now I am a little confused. So now it sounds like now you're saying it will always be the case that under the government's decision that's being challenged here,
Yes.
it will always be the case, or it will never be the case that you get more money.
It will always be the case under the challenge decision that the inclusion of the Medicare Part C days in the denominator of the Medicare fraction will deflate the Medicare fraction, which is 1/2 of the larger ratio.
But it could inflate the Medicaid fraction so much.
No, I understood what the discussion earlier that they were talking about an adjustment that could later happen with inputs into the Medicaid fraction, which
No,
is
that's not my
separate.
question.
Oh, I apologize. I misunderstood your question.
My question is deflating the Medicare fraction by itself means you get less money, right?
Always.
Okay. And is it ever the case that because you have deflated the Medicare fraction, you are inflating the Medicaid fraction so much that you're going to get more money at the end of the day?
If I haven't demonstrated I'm bad at math already, but no, my answer to that is no. That should not be the case. No.
Okay.
One other piece that was pointed out there, I see I'm out of time. Your Honor, are there any other questions?
I don't believe so.
I'll ask one
Yeah.
more. Well, I asked Mr. Kennedy about whether the government would ever kind of flunk its own test. Its test being a pronouncement is not a determination as to the amount of the payment if it fails to resolve every remaining variable. And Mr. Kennedy said, no, the government will never flunk that test. The government would never say something is reviewable unless it satisfies that standard. Do you agree with Mr. Kennedy when he says the government would never flunk its own test?
The test that there are no variables. No, I don't. I agree with the other cases that have been cited.
What's an example of a time when the government allows an A1, A2 challenge, even though the CMS determination has not resolved every remaining variable?
Where the government allows that?
Yeah, where the government concedes that the challenge is ripe.
This court has found in these final rules, for example, I think you look to wage index cases, for example, or Cape Cod, where there was a rate setting challenge. I think those are prospectively setting, as the amici point out, they're prospectively setting rates and adjusting rates that will be paid, but there are other variables that are not yet set in what the final payment amount is going to be in an NPR. That final payment amount in an NPR is going to include many variables that are estimated rates. That includes DISH, it includes outlier payments. It'll be at the end of the year, and those are estimates throughout the year. So I don't think that meets that same standard.
I'd go to Cape Cod and find is that a case you're talking?
Yeah, I'm sorry.
I'd go to the Cape Cod case and I'd see, well, here the government is basically.
I don't think the government says that. I think that's what Cape Cod is. It points to, it's an IPPS final rule appeal, and final rule appeals by nature include lots of different variables that are in them. I don't think they stand for the principle that all variables have been set in advance and we know what the actual amount that a hospital is going to receive at the end of the year is, which is what I understand the government's position to be. It's a rule that's going to set rates. Thank you, Your Honors.
Thank you, counsel. Mr. Kennedy, we'll give you 2 minutes for a rebuttal.
Great. I'd just like to address two things that my friend on the other side said. First, on that last point, with respect to the IPPS rule, when the IPPS rule comes out, hospitals know precisely the per patient amount that they're going to be paid. And that's why they can bring a challenge under Romanet 2, because there's been a final determination as to the amount of the payment that they will be paid under the respective payment system. They don't know the total reimbursement that they're going to receive because that total reimbursement depends on cost year data. They couldn't bring a challenge under 1. That occurs only in the notice of program reimbursement. That's very different from the case here where they don't know the per patient amount because the very per patient amount is determined retroactively and determined based on cost year data. So in one case, the cost year data comes after the per patient amount in the federal base rates. In the other, the cost year data comes before the determination of the per patient amount. And that's what separates them. Second, the idea that interim payments somehow makes the disproportionate share adjustment prospective is wrong. The final payment determination, those are just placeholder payments that can be revised.
Sort of,
Yeah,
right?
they're advances. The hospitals have no statutory right to them. They can be revised up or down. They're expressly non-final determinations as to the amount of payment. They're just advances. So if the court has no further questions, I urge the court to reverse.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.